Good morning. Are you Jamon Adams?
Yes, ma'am.
This is 26 DCCR 0744. It looks like Mr. Adams is charged with aggravated assault with a deadly weapon, and Mr. Rojas has filed a motion asking that I reduce the bond currently set at 150,000. Is that correct?
That's correct, Your Honor.
Mr. Adams, the best you can, raise your right hand, please, sir. Do you swear?
Oh, yeah.
Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Go ahead, Mr. Rojas.
Hey, Jim, how old are you?
21,
Where are you originally from?
Houston.
Okay, but when this incident happened, you were living here in town with your dad?
Yes, sir.
And your dad's the victim of this, is complaining witness in this case, right?
Yes, sir.
Okay. How long have you been in jail?
Since April 8th.
And the only other person other than your father that can realistically help you with this is your mom, right?
Yes, sir.
Okay, and your mom, you've talked with her and you've talked to them, she's unable to make a bond for $150,000.
No, sir.
Okay. Do you own any property that you could sell, a house, a car, a land? Do you have a bank account in your name?
Yes, sir.
Do you know approximately how much money is in that account?
Probably zero, maybe in the negative.
Okay. This is, again, you're 17 years old. This is the very first time you've been arrested, right?
Yes, sir.
Okay. Your mom's gonna help you out with the bond if we can get it lowered, and I think maybe an aunt, he said maybe there's an aunt out there that can help her.
Yes.
Okay. Are you married?
No, sir.
Do you have any kids?
No, sir.
Okay, so it's just you.
Just me.
So if you're able to make a bond, like I said, before this, you were living with your dad, what's your plan? If the judge will let you, want to go live with your mom in Austin?
Yeah, so I will go to Austin. I already have a job lined up for myself. She's holding it down for me right now. She's also working to get her own apartment so that I can go move in with her, I can start working and continue back on my plan to get back in school.
Okay, and you say get back in school, but was that high school?
No,
Okay, where were you going to college at?
probably did relate to university. It's in San Antonio.
Okay. And once you're able to get this all behind you, that's your plan to get back into college?
Yes.
All right. That's witness Jeff.
Just so we're clear, you're 21 years old, right? Not 17. I think that was a misstatement.
Yes.
Okay.
21, yes.
Apologize. Did I say that?
I think you said 17. I know it's an error.
Nice.
I have another question, Joe.
Okay. Any other witnesses?
No, Judge.
Mr. Nichols, what's the state's position?
Judge, he's accused of breaking into his own home after he'd been kicked out, and when his father tried to push him out the window that he broke in through, he grabbed a knife and stabbed him. I think 150 is appropriate in this situation, Judge.
And for the record, I am taking judicial notice of the court's file. It includes the probable cause affidavit. If you'll give me just a second, let me So you said you would be going to Austin if you make bond, no matter what that is, and living with your mom, is that correct?
Yes.
But that she would be getting her own place. Where does she live now?
I believe it's one of those homes where she's pays for that space.
Okay,
I believe the money she's paying there, she can also pay for an apartment. So that's what she's doing while working both jobs.
and what's the job that you would have?
I would have the IHOP job. That's her second job. That's the job that I will be going to.
When's the last time you were in school?
I believe in May of 2024. That's when I left college. Then keep up the $40,000.
Speak up.
I said I cannot keep up the $40,000 on my own for tuition.
Any history that you can?
Minor juvenile, I think an arrest and a non-suit out of Harris County for burglary when he was a juvenile, but nothing else, right?
All right, so what I'm gonna do, Mr. Adams, I'm going to grant the motion. I'm going to reduce your bond to $100,000. condition of that bond, if you make it, is going to be that you obviously have absolutely no contact, no communication with David Keys. You will be ordered to wear a GPS monitoring device. You will be allowed to live in Austin with your mom. You would have to get that address before you go to your attorney or to your bondsman. And also obviously not be anywhere near the residence at 1970 Ave Street. Do you understand?
Yes, ma'am.
No contact and no communication means none. That not sending messages obviously means in person, but it also means sending any type of messages yourself or through anybody else or anything like that. You understand?
Yes, ma'am. I have no intentions.
And we'll reset it for an announcement. All right, you can go back with the bailiff.
Thank you.
Thank you. Thank you.
Good morning. Are you Kashonda Renee Riley?
Yes, ma'am.
Will your client waive a formal reading of the indictments and the motion?
She will, Your Honor.
Ms. Riley, in cause number 26 BCCR 0210, you're charged with a state jail felony offense of theft of property with previous convictions from December 20th of 2025. The indictment alleges that you were previously convicted of theft August 25th of 2017, and then 2 cases on March 1st of 2023. And how do you plead to that charge?
Yes,
And are those prior convictions true?
yes,
Did you enter your plea of guilty and true in this case freely and voluntarily?
yes,
And did you plead guilty because you actually did what they've charged you with?
yes.
Then in clause number 26, DCCR 0211, you're also charged with theft of property with previous convictions, a state jail felony, and this is from November 24th of 2025. It alleges those same prior convictions for theft, and how do you plead to this charge?
Yes,
And again, are those prior convictions true?
yes,
And you entered your plea of guilty and true freely and voluntarily,
yes, ma'am.
and because you actually did what they've charged you with.
Yes,
In each of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
yes,
And you understand if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
yes,
And it looks like the agreements that you've reached in these 2 cases is for a cap of 15 months in the state jail prison, which means if I follow the agreement, I cannot give you more than 15 months. I can give you 15 months, I can give you less. It'll depend on the information that I receive when we come back from sentencing or for sentencing. You have an absolute right to have a jury come in and decide 2 things. The first is to decide if you're guilty or not. And then if that jury finds you guilty, you could leave your punishment up to them. If we go forward this way, you're waiving that and leaving it up to me. And is that what you want to do?
yes,
State tenders number 1 in each of those cases.
No objection.
It's admitted in each case. Is there any evidence that Ms. Riley is not competent?
No, Your Honor.
All right, ma'am, in each of these cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset both of those cases so that we can get a pre-sentence report done. That'll give me some more information about you and the cases, and then we'll come back later for sentencing.
yes, ma'am.
And then we have cause number 24, DCCR 1778. Give me just a second. All right, this shows that you were, this is a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 21st of 2025 for the offense of theft of property with previous convictions, a state jail felony. And that was a 3-year deferred probation. Is that correct?
Yes, ma'am.
It alleges you violated your probation. Count 1 alleges that you committed the new offense of theft of property with previous convictions December 20th of 2025. And is that true or not true?
Yes, ma'am. It's true.
And then count 2 alleges that you committed the offense of failure to ID a fugitive with intent to give false information on December 20th of 2025. And is that true or not true?
True.
Count 3 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
Count 4 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
True.
And then count 5 alleges that you are behind in your court assessed fees. Is that true or not true? Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes.
And did you plead true to those counts because they're all actually true?
Yes.
I also have here on the tablet, in that case, some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Mr. Rojas?
Yes.
And you understand if I follow the agreement, which is a cap of 15 months in this case as well, that you'll be waiving or giving up any right to appeal.
Yes.
State tenders number 1.
No objection.
All right, it's admitted. All right, Ms. Riley, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm going to hold on that and reset your case for sentencing. Again, I'll get an updated report from probation and then we'll see what we get when we come back. If there's anything that you think is important for me to know, get that information to Mr. Rojas and he'll present it to me on your behalf when you come back. All right?
Judge, a first amended motion was prepared on Friday to be filed. I'm going to
Okay.
hold it since we've reached an agreement on everything and it won't be filed. All it did was add one of the cases she's already pleaded guilty to.
Okay, all right, thank you. All right, you can go back with the bailiff. Good morning. Are you Cody Arnold?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Here we are.
Mr. Arnold, in cause number 26, DCCR 0488, you're charged with the 3rd-degree felony offense of harassment of a public servant from January 30th good grief, January 30th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Arnold is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the 3rd-degree felony offense of harassment of a public servant. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Do you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts? You can talk to Mr. Rojas. All right, good luck to you, sir. You go back with the bailiff.
Yeah, go.
Bethany Batten. You're Bethany Batten?
Yes, ma'am.
And this is cause number 24, DCCR 2349. I am going to take judicial notice of the court's file. I think we've already gone through this, but just to make sure the record clear, Ms. Batten was previously found not competent to stand trial, sent to the John Dunn Behavioral Science Center for Competency Restoration, was sent back here. It looks like we got a report April 3rd of 2026 that Ms. Batten was now currently competent to stand trial. Any other issues with regard to competency?
No, Your Honor, not from the state.
All right, then I'll make that finding that she is competent to stand trial. Will she waive the formal reading of the indictment?
She will, Your Honor.
Ms. Batten, you're charged with the 3rd-degree felony offense of assault on a security officer, and that's from November 14th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation,
Yes.
exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. All right, Ms. Batten, I'm going to find that you entered your plea of guilty freely and voluntarily. I find again that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of assault on a security officer. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to me.